Welcome to the Right to Financial Privacy Act. In this training, we will learn about the Right to Financial Privacy Act, the methods a government agency may use to request financial information, method requirements, the responsibilities of a financial institution, penalties for non-compliance, and best practices. The Right to Financial Privacy Act, enacted in 1978, requires federal government agencies to adhere to standards for obtaining a consumer's financial records from financial institutions. It protects consumers' financial records from unjustifiable access by the federal government. Financial institutions must act to safeguard consumer records by screening requests for information to make sure it meets the requirements. Who does the RFPA apply to? The Act does not apply to private party requests from state government representatives. However, it applies to consumers or a representative of the consumer that have used any service of a financial institution. It includes persons that have their assets, such as money or property, managed for their benefit by a financial institution. The law encompasses any record held by a financial institution in relation to the consumer's communication with the institution. RFPA does not apply with regulatory exams. Agencies are entitled to examine all records in their supervisory functions. If the financial institution believes an employee, officer, agent, director, controlling shareholder, or major borrower is involved in illegal activity, then records may be disclosed to state law enforcement agency or U.S. attorney. Information required to be reported under federal law or regulation does not apply, such as information required to be reported to FinCEN under the Bank Secrecy Act. If a government agency seeks records under federal rules of civil or criminal procedure, then the Act does not apply. In these cases, consult with your legal department and ask for written certification of compliance from the government agency prior to releasing records. Financial institutions must receive one of the following methods for request of information from the government agency: written authorization from the consumer, administrative subpoena or summons, a search warrant, a judicial subpoena, or a formal written request from the government agency. The government agency request method must include specific criteria that will be analyzed by finance companies to ensure their validity. Let's review each method's requirements. A written authorization must be signed and dated by the consumer. It must state the reason for disclosure, identify the records to be disclosed, state the authorization is only valid for 3 months, in which the authorization then expires. It must state the consumer has received information on their rights under the Right to Financial Privacy Act. And it must also state the consumer may cancel the authorization at any time before the records are released by the finance company. An administrative or judicial subpoena or summons must have been served to the consumer or mailed to their last known address. Financial institutions must wait 10 days from the time of service or 14 days from the time of mailing before releasing the records. If a consumer filed a motion to quash or cancel the subpoena, the financial institution cannot release the records. A copy of the consumer's motion to quash with a clerk seal or stamp must be received to honor cancellation. A copy of the search warrant must be mailed to the consumer within 90 days after service. This may be delayed under court order if there is a reason to believe that notifying the consumer beforehand may result in endangering the life or physical safety of any person, a flight risk, tampering or destroying evidence, or intimidation of a potential witness, or would jeopardize the investigation. A formal written government agency request must only be used when an administrative subpoena or summons is not available. It must be authorized by regulation and to legitimate law enforcement inquiries. A copy of the notice must be served to the consumer or mailed to their last known address. Financial institutions must wait 10 days from the time of service or 14 days from the time of mailing before releasing the records. If a consumer has filed a sworn statement or application to dispute the government request in a suitable court, the financial institution cannot release the records. The cost for a financial institution furnishing records, such as printing, transporting, or assembly, must be reimbursed by the government agency. Financial institutions cannot release records until a written certification is provided by the government agency that they have indeed complied to RFPA. To avoid liability under the Act, always act on a certificate of compliance. Keep track of instances when consumers' records have been disclosed by a consumer's written authorization, including date, name of agency, and the records that were disclosed. Allow consumers to review records upon request, unless blocked by a court order. Keep copies of all subpoenas, search warrants, formal written requests, and written certification that is required. Financial institutions are required to begin gathering the records once a government agency requests them using one of the approved methods. Be prepared to deliver records upon receipt of the written certification of compliance. Financial institutions who fail to follow all RFPA guidelines may be required to pay civil monetary penalties of $100 per occurrence, plus actual damages. If a financial institution is found to have purposefully violated RFPA, punitive damages may be imposed, plus any legal fees. Here are best practices financial institutions should follow to ensure consumers' financial privacy. Make sure to understand your financial policy and procedures. Do not release records unless you have a written certification of compliance from the government agency. Review files to be provided carefully and remove any documents unrelated to the request. Only the documents identified in the request are to be provided. Some documents may be protected under institution's attorney-client privilege and not subject to subpoena. Other documents may contain financial information of another consumer. Have the documents double-checked by another employee prior to delivery. Consult with your legal department if questions arise. Thank you for participating in the Right to Financial Privacy Act. Have a great day!